longer than 15 minutes for lunch, because we do not have a we do not have a cafeteria. And some of us may have brought a lunch and some may need to go out. So I would anticipate this afternoon going beyond 2 o'clock. And for the folks who are testifying at 12:30, I would really like to push them back to 1 o'clock if possible for that. And they're all on Zoom, so that will give us some flexibility there. And also the DOC facility staffing issue would probably get pushed back as well, but I really want to provide more than 15 minutes for lunch. We're going to need at least a half hour, 45 minutes. People go downtown, get something. You don't realize how important that cafeteria is until you don't have it. And there's not much open.
I got the gas station.
Can you get a sandwich?
Yeah.
Something on State Street?
It's down the street from the chicken at that intersection with the bridge. Actually, just go down 4th Street, that 4-way intersection. It's catty.
Maybe we'll send somebody for a run.
Hey.
Yeah, right. We'll have to do the best we can, but I want to accommodate, make sure people have lunch. Maybe the thing to do is just go out and buy it and bring it back and eat. I've got half a potato.
Well, I was sharing with anybody. You didn't accept.
And we cannot eat in here, so we have to figure out, we can eat in room 10. We can also go up to the cafeteria as well, but we cannot eat in this room. So we'll figure something out. So with that said, let's go live if we weren't already.
We are live.
We are live. Okay. So we were talking about logistics on the committee. So this next piece is dealing with Senate Bill 7, which then became Act 58, I believe. And it really came out of both the Senate and the House Judiciary Committee. And there is a charge to our Justice Oversight Committee that would really be looking at how to simplify and automate the process of expungement and sealing of criminal history records, and to consider the policy for those issues. And some of that could be what crimes would be eligible for expungement, what crimes would not be. So this is, if people want to find it, we did go through this with our legal counsel last month, Bryn Hare. It is in Act 58, and it is Section 5 that pertains to our Justice Oversight Committee. So with that, I will ask Senator Sears and also Representative Grad if there's any introductions they would like to give or correction in terms of what I placed. Anything?
I just thank the committee for taking this up. It's an extremely important issue. We've had tremendous success in people getting records expunged in the state already. But trying to simplify this system, I think we all agree would be helpful. It seems like we have done piecemeal additions to crimes over the years, and hopefully this would be an opportunity to improve the system. There's also an awful lot of misinformation that was contained in a number of letters from the administration to the two judiciary committees. And part of that was risk needs assessments and that sort of thing, and how it might impact expungements. There's also a desire on the part of law enforcement to be able to have access to records. But if you're expunged, why should you have access? A lot of those types of issues that came up. And so working with Representative Grad, we decided to move forward with S7, but adding this study by the Justice Oversight Committee. It's important to note that the original S7 that was passed by the Senate contained most recommendations from the Sentencing Commission, which was made up of members of the administration, the legislative and judicial branches, as well as state attorneys, defense bar, and so forth. So we thought that it had been pretty well vetted, but back sometime in late April, the administration sent a letter to myself and Representative Grad expressing great concern about the bill. And frankly, we were both surprised since they had been involved with the Sentencing Commission and knew that most of these were recommendations of the Sentencing Commission. But trying to work together with the administration, our goal now is to what you just outlined, Madam Chair.
Thank you. Anything else, Representative Graham? Okay. So with that, we'll start with Judge Grierson. Judge, welcome.
Good morning. Good morning, everyone. Thank you, Madam Chair. It's good to be back in
Yes, it
person.
is. It's great.
See everyone again. Told my wife before I left, for the record, Brian Grierson, Chief Superior Judge. It was almost like the first day of school, putting on a suit and learning how to retie a tie and
Did it fit?
tied shoes and all of that, and going to a public building. I said, it feels like the first day of school, seeing who the new kids are and reacquainting myself with the old kids. So
That's great.
here I am, but it's good to be here, good to be here in person. Obviously, I've been involved over the years in the ongoing discussion about expungement and the process and the offenses. I think as I look at S7, Act 58, and specifically Section 5, the policy decision on which offenses should be included in the list for expungement is a policy decision and not one that I will get into today. I think my comments would focus on the process to assist the legislature in understanding the impact on the judiciary. I would say that on the good news with the introduction of the new case management system, Odyssey, which has now been implemented throughout the state, that I think we're in a position to have a more automated system of tracking cases from the time of sealing through what we now refer to as expungement. But because all records, court records anyway, are now electronic, the distinction between expunging a record and sealing a record has changed. It's really different for us. Think of the Odyssey, the new case management system, from the time a case is filed, putting aside expungement at the end of the line. As soon as a case is filed, there is a determination, depending on who the person is filing, who has access to those records throughout the entire process. And one of the terms that is used is who has permission to be able to view a record. So I think legislatures should start looking at least court records in that manner. Who has permission to access these records? Because that's really what sealing and the process of expungement is really all about. And I think the case management system allows us to automate that system to a greater degree than we used to, and I'll explain why. As many of the members of this committee know, when I've testified in front of them, I always try to avoid and remind the legislature, this is not automatic. It still requires a staff person to make the entries that go along with the case. So when I use the word automated, I'm talking about hopefully streamlining the process, but not automatic. So if we, and I have, I think in both Senate Judiciary in front of Senator Sears and in front of Representative Grad, my thinking has been, with the advent of this case management system, that we really could focus in on sealing and look at sealing, because the end result of a sealing process is effectively the same as expungement. In other words, at the end of the line, at the end of the sealing process, expungement will mean no one has permission to access that record. Other than currently in the statute, there's an index that's maintained, but beyond that, that's really what expungement will mean. That whatever permissions the legislature sees fit to grant over the life of the sealing of a record, at the end of the line, all permissions would be withdrawn. That is effectively what expungement will be under our case management system. That's not speaking of records maintained by law enforcement, state's attorneys, and so forth, or under entities. But that's the way the court records would be. So to the extent that the statutes now say whether it's sealing or expungement, if you remember, they say the exact same thing. No such record exists. So we're close to really having one system. You can still use the term expungement, but I just want to make sure the legislature understands that for our purposes, court records, it's just a different entry at some point in time that this record can no longer be accessed by anyone, permission. So what the issues that I see in Section 5 relate to who has that access. When the well, two things. One, to determine the starting point of the process, sealing process, we have to know that the case in the sentence has been served. Now, obviously, if the offense is one where the penalty is a fine, that's a record that we would maintain, and we would know that the fine has been paid, and therefore the sentence has been served, and the case is appropriate for sealing. It's the other cases, and I've talked with Dale Crook about this, and I think we testified during the course of legislation, that really what we need is communication between the Department of Corrections and the judiciary, so that the Department of Corrections notifies us when a sentence has been served, when someone has been, they're no longer under DOC custody, because that would be the triggering event for the judiciary to say, all right, the timeline for this case to be considered for sealing starts on day X. Without that, we will never know. And in many instances, it's only the Department of Corrections will have that. Right now, we do not get that information. In some cases, we do, but that's one step in the sealing process. We have to know when the sentence has been completed. That would start the sealing process. Then the question becomes, I think, who has access to sealed records, and how do they gain that access? For what purpose and how long? And those are really questions the legislature has to come to grips with under the current statutory framework. And maybe it's an overly broad reading on my part, and others who are testifying may disagree, but I view under the current sealing statutes that it's effectively sealed for everyone but law enforcement. They, generally speaking, have access to sealed files for any of their purposes. So we've already got a large exception to sealing, and the legislature may see fit to continue that. That's obviously, again, another policy decision.
Madam Chair.
Yes. Go ahead, Senator Brewer.
Thank you, Judge Pearson. I understand what you're saying, and I agree that, you know, from a pragmatic standpoint, it really is about who has access. But it seems to me that we did sell expungement as something different. Expungement was meant to be literally the expungement of your record, which is a fundamentally different thing from having your record remain, but having it be open to law enforcement. And I believe S7 also talks about research databases.
Yes.
So you have researchers and law enforcement who still have access to your criminal history, as opposed to when we first started this and we were destroying actual tapes, audio tapes. As I remember, there was talk about how to expunge actual, court stenographer records and things like that. So I see that we're engaged now in a process of trying to rationalize something that we went into maybe not fully understanding it. But the thing I remain concerned about is that we do seem, at least if we take this view of the case management system and sealing as really what we're doing, it seems that we're giving up on expungement as an actual literal concept. And instead, what we would be saying is no record exists when in fact records do exist and could potentially come out. Can you just speak to that? Because I think in some ways that's the philosophical crux of the matter.
So let me go back for a minute. When we were talking about the status of records before the case management system, there were essentially two major problems. One is the really old records that are in microfiche, I think somewhere in Middlesex in a warehouse, and the inability to literally expunge those records by going in with microfiche and a razor blade and clearing the records. That was one thing. But there, at one point in this process, recognizing what it meant to literally destroy a record, that's why the language was amended a few years ago to say that no record exists when, as you've indicated, the reality is there may be a paper file. And that's because of.
Yeah. And I remember that hearing, and it might have been a loaded term, but it struck me as Orwellian that someone would put in a request and the answer would come back, no record exists, when in fact the state knows that there are such records. So I think there are a few different ethical principles that we're working with, and one is the idea of expungement and the name expungement. For me, it's not as simple as just saying, well, let's call everything sealing, because there was a project that we were promising to people, which is your record will no longer be there. And it seems like what we're talking about now is moving entirely away from that. Am I correct in that?
I don't think so, because even, I just want to clarify one piece that you mentioned, talking about access to records for research purposes. The difference is that someone seeking those records has to apply to my office. In other words, they don't have that access that I see law enforcement has under a sealed record. So even under the current system, once the records are expunged, as that has now been defined by the legislature as no record exists, a person would still have to seek permission through my office, Office of Chief Superior Judge, to access those records, even for expungement purposes. I mean, for research purposes. And that's why I'm saying, I think what the legislature has to deal with, has to address is, okay, what does it mean now that there is an electronic record? And is expungement exist in an electronic world? When you think about it. But at the same time, you can be asking yourselves whether the sealing process and the process that I've described serves the ultimate purpose of the record not being there. And yes, it's different than what it was when we had essentially a paper world. But I think now is a good time to look at the process that's in place and say, what do we need?
No, and I would agree. I guess I don't see the substantial difference between an electronic record. It doesn't seem to me that would be harder to expunge than a physical record. Because, I mean, correct me if I'm wrong, technically, you could erase someone's file.
I'm sure there's a button you could press that would say gone. I don't know if it's really gone or someone can't retrieve it, but then as long as you continue to have that provision in there, that someone can access the record for research purposes, that's where I think we're now living in yet another Orwellian world where we've said the record doesn't exist, but if you really need it, apply to this office and we can get it for you. And I think that's the struggle.
Yeah, I guess what I'm hoping to do is foreground a question of whether we should be using the word expungement at all. And if we are, then I think it should mean expungement as opposed to sealing. Otherwise, we might as well just get rid of the concept if we're no longer promising that to people who are looking for that remedy.
And quite frankly, that's my suggestion, whether I'm alone in that recommendation or not. I think we should go to a process where it's a level of permission or access all along the way, and it should continue that way once the records are in the sealing state. And then in the final decision is, when is this record no longer available to anyone other than seeking permission through, whether it's my office or it's not important how it's done, but you need permission to do it. And that's why I'm saying, I think getting hung up on the word expungement, we really have to look at what records are we addressing and how do we either deny permission or deny access. That's what I'm.
Madam Chair.
Yep.
you-
Senator Sears?
Yeah, you're at a fundamental issue here. And I think the next statement, I'm glad that Senator Baruth has raised this issue, is what can you do with that record? If the researchers can't divulge any information about the person who's the subject of the record, and that's one thing, and it's only used for research purposes. But if it's in law enforcement's hands and they can use that for whatever purpose, and that's a different thing. And I think if we're going to disband with expungement, the legislature has to be very clear on what does access to the record mean and how can it be used. So if it's a DUI and it's a predicate offense, or domestic violence and it's a predicate offense, that would be one thing. But if it's going to be used against somebody who had a sale of marijuana 40 years ago, which was back when they arrested people for handing a joint to another person, that would be a different matter in how that's used. I really am concerned that if we're going to move away from expungement, that we be extremely clear on what the uses of that information would be.
I would certainly agree with that statement. I think that's what I'm trying to convey.
Questions? Other questions?
The only other thing I will tell you is, so once we move through this process, it's under sealing, the question who can access for what purpose. But then at the end of the line, when the idea is, okay, permission will be denied for everyone. There will be no access to that record, effectively what we now refer to as expungement. It can be automatic in this sense. When that date of sealing occurs, and let's just by way of example say it's 7 years after it's sealed, it can be expunged. This system will not do it automatically, but it will trigger that date, 7 years from the date it goes under sealing. And then the staff person will get a trigger, tickler, whatever system you want to call it. And they can go in and then hit that button that says all permissions denied, no further access. But the question then becomes, and it's in, I believe in section 5, is to what extent is the state's attorney's office, the prosecuting office, involved in that process? What kind of notice do they have to get that the court is about to deny permission for anyone? And I think that's, again, that's an issue that the legislature has to come to grips with. How is that done? Because it should not be a staff decision when that date hits to then review whatever other cases may be pending or have been resolved with that same person during the lifetime of that sealing process. And you do not want the staff person, nor do we want the responsibility for staff to make the decision, well, I've checked the record. I'm going to expunge it based on my review of the record. So you can choose to make it, if I would use the term loosely, automatic, that on that date, you're not going to involve any other parties, and it will be a decision by the court to enter permission denied, other than as laid out in the current statute. Or you've got to, and I'm sure Evan or John Campbell will have something to say about the notice process. and whether, when it goes under sealing, is it the state's attorney's responsibility, working with the judiciary to maintain their own system, so that when that so-called final date comes up, it's the state's attorney has the obligation to notify the court. This case is coming up for permission denied. We want to request a hearing because the person maybe has been convicted of other offenses, or they have some other reason under the statute to oppose that final decision. And so I think, again, that's the final issue as to how that notice would go out, or would the notice go out. And I'm sure that the state's attorneys will want that notice to go out. It's a question of how that is handled. And then we go from there.
Questions?
Thank you.
Anything else, Judge?
No,
Okay,
I don't believe so.
thank you. So we do have another judge, Judge Zoning. Is that how you- Zoning, okay, sorry, welcome. Good morning.
Those who I had the pleasure of meeting, I'm Judge Tom Zone. I'm a Superior Court judge. I am also the chair of the Sentencing Commission. I am here today not as the chair, but the Sentencing Commission, although certainly that informs what I'm going to talk about, which will be brief given the time constraints and lunch coming up for the members of this committee. I agree with much of what Judge Grierson said, if not all of it. I think that what Senator Sears originally talked about was, he said they adopted what the Sentencing Commission had come up with. And that was a report we issued back in October of 2019 in response to Act 32. Since then, we had the House Judiciary as well as the Senate Judiciary work on the changes to expungement, which, as Senator Sears pointed out, in large part went with what the Sentencing Commission had, I believe, unanimously recommended. When you look at Section 5 of S7, it had 4 separate questions for this group. The first question, as Judge Grierson pointed out, involved should something be automatic? And he, I think, explained what that really means. There's also a policy decision there, and that's for the legislature. What crimes should be included? Sentencing Commission had made a recommendation, but that's also a policy decision for the legislature. Who has access? Again, a policy decision for the legislature. I would offer that as far as access goes, there has been times where individuals who may have had the benefit of an expungement actually are harmed. Because if the records are now destroyed in an information age where everything goes out online right away, that individual may actually want to get a copy of the record. And if we actually destroy all records, then it might actually have a negative impact on law enforcement, on public safety, and on the very individuals who the expungement was seeking to protect. And that was noted in the Sentencing Commission's recommendations previously. The third question that was asked of this group in Section 5 was, should we have a 2-track system or a 1-track system? My position is 1-track system. I think we need to uncomplicate what is complicated. If you look at 13 VSA, Section 7606, which talks about the effect of expungement, and the next section, 7607, which talks about the effect of sealing, they're basically identical for the effect. Until what? Until you get to the access question. And that, again, is a question for a policy decision by the legislature. As Judge Grierson said, it's up to the legislature to decide, what do you want as far as who gets access? And Senator Sears is correct. I agree with him. Whoever has access, it needs to be made clear. Whatever policy you choose, it should be made very clear as to who's going to get access. But the idea that we have these 2 tracks, it does get confusing. It does get difficult for people to understand as they're trying to navigate, well, okay, today I'm going to file for expungement, but wait, no, I should really be filing for sealing. It should be simplified. If the intent is to have a process that benefits the individuals who are affected by it and provides a clear and direct process that everyone in society is aware of, let's streamline it. And then when you get to the question of automatic, I think Judge Grierson's correct there also. Automatic, what does it really mean? Do we just say on a certain date something goes away? It could mean that. I would suggest there's negatives to that because there are legitimate law enforcement needs that might come into it. I have seen cases where there's been applications for sealing or expungement where it was the state's attorney's office who brought information to the court that I don't think otherwise would have gotten there. That showed that not only was it inappropriate, but it was not authorized. And so the input of the state's attorneys and the Attorney General's office into the process is critical. So whatever the legislature decides to set up as far as a notice requirement, please make sure it includes something that has them involved. I think technologically, from working in the trial courts, I do think it works to have information sent out from the clerks perhaps to the state's attorney and say, you have until this date to object. And after that, then the court may order expungement. But I do think there should be some form of notice. I think that if we expected the state's attorney's office to keep a running list in their offices of every case that's going to be eligible and on what date, I don't think that's reasonable. And I do think we spend a lot of time and effort on a very effective case management system. And Judge Grierson may not want me to say this, he may not agree, but I think we should own some of the responsibility to assure that when we're making these important decisions, we do it in a way that maximizes the administration of the statutes that you implement. And one other thing I do want to touch on, if I could, Senator Baruth, when you talked about your concern about giving up expungement as a literal concept, and it really struck me when you said that no record exists, and that bothers you because a record does exist. I would suggest that one way to address that is in any statutory enactment, you can just define the word record to say that as used in this chapter, the term record means information which in any form may be available for public inspection. And something like that may be a way to be, I'll call it intellectually honest on that. Because I share your concern that when we say, well, nothing exists and we know it does, what message are we sending?
Yeah, I thank you for that. I also find myself wondering if we should be thinking, if we're going down the one track direction and we're thinking about how to rationalize what already exists on the books. I do wonder about the circumstances under which it can be accessed, but also what if any penalties would there be for somebody improperly accessing those records? Because I think when we talk about the people that this is looking to serve, they're often people who made a mistake in their youth, 20 years ago, 25 years ago. They, and I heard from some of them when we were doing expungement as a literal concept, they liked the idea that it was gone, that no one could find it in the internet age, that it couldn't somehow escape a database or be leaked. So maybe that's something we could ask the judiciary for advice on. Is there a way to clarify in statute that there are penalties for improper access or breaking sealing? Because I worry that it will become the sort of thing where it's technically sealed, technically not supposed to be out there, but someone with access gets a little too comfortable with sharing that information. So looking to make people who depended on literal expungement comfortable with sealing.
Well, certainly the legislature, as part of any statutory enactment, could determine appropriate consequences for someone who may have violated the provisions. And that's, again, a policy decision for the legislature to consider. Anything further?
Any questions?
Thank you very much
Yes,
for
Amy.
allowing me to be
Thank
here.
you.
And I would echo Judge Grierson. It's really nice to see people.
Yes.
It's a pleasure to be here.
I think
Thank
we
you.
all feel that way. It's good. And we miss the folks who are on Zoom. Miss them. The next one is David Shear from the Attorney General's office.
Thank you, Madam Chair. For the record, David Scher, Assistant Attorney General with the Attorney General's office. And I'll echo what others have said. It's really good to see folks in 3 dimensions, at least most of us. It's great to be here. As this committee knows well, the Attorney General is a very strong supporter of expungement. He's testified to that effect. And this committee, as well as in both of the judiciary committees at various times, our office helps run expungement clinics around the state. We actually have another one coming up on July 30th in Rutland County in cooperation with State's Attorney Kennedy down there. So the Attorney General is a believer in this. The policy reasons are compelling. I won't belabor the policy reasons too much because I realize we're here today mostly to talk about process and mechanisms. But just to remind folks, it is a pro-public safety, a pro-jobs innovation to expand expungement. Expungements, we have studies showing that people who access expungements have lower rates of reoffense. They receive significant pay increases and job stability. Arrest rates for those who receive expungements can drop below the level of arrest rates for the general population. And in terms of public safety of folks who have committed offenses in the past, we have strong data showing that after a number of years, the number cited is often 7 for relatively serious offenses, actually for offenses more serious than were contemplated in S7 as it passed the Senate. For even fairly serious offenses, if somebody does not reoffend for 7 years after that, their risk of reoffense drops to that of the general population. So we are not talking, there is a strong argument that there is not a significant public safety risk after sufficient time has passed. We can obviously talk about that more in the future, but want to jump in a little bit to the process and mechanisms question, which is what S7 directs us to do and Section 5 directs us to do. As Senator Sears spoke about at the beginning, there actually is a lot of support for a broad expungement regime here in Vermont. As Judge Zone mentioned, the Vermont Sentencing Commission did pass a resolution, or I should say a recommendation to the legislature. That recommendation essentially became the version of S7 that passed the Senate. That, again, was a broad-based bill. It did include a lot of offenses other than really the listed offenses and a few others that were enumerated. And that recommendation did have unanimous support out of the Sentencing Commission, which did include a lot of different stakeholders, including Department of Public Safety, Department of Corrections, Center for Crime Victim Services. I think it's fair to say that that was a result of compromise. It was neither as expansive as the strongest proponents of expungement wanted, nor was it as tight as some of the law enforcement representatives would have preferred. And oftentimes when you come to compromise, you can increase complexity in order to deal with the various issues that folks are concerned about. And I think that did happen with that recommendation. As I was looking at Section 5 here of S7, reviewing that again recently, I actually think that the committee's legislative, should say judiciary committee, as they formulated this, I was reminded that they were already looking towards some of the ways that could simplify it, and I think appropriately so. One of the ways in which we reached compromise in the Vermont Sentencing Commission report was to have this sort of 2-track process where sealing happened first for some of the more serious offenses, and then expungement was only available later. It is true that that adds labor, adds complexity, and so forth, and I think that a 1-track process could well be a more reasonable way to accomplish it. And I should say, our office, the Attorney General, has always been fairly agnostic, actually, in terms of what the appropriate process should be. And we certainly supported the Vermont Sentencing Commission recommendation because that got a lot of agreement. But if we can come to an agreement on a different, more simple process, that's great, and we should do that. Section 5 does again gesture towards a couple of the ways that we do that. One of them is 1-track process. I think in order, one way to achieve that, as Senator Baruth gestured towards, to simply say, well, we will have expungement, true expungement as it's contemplated in statute right now. I think if we're going to have, a more broad-based buy-in, we'll probably have to think about how we define expungement and sealing, and think about how that might be changed in order to address the concerns of law enforcement actors, as well as those who are strong proponents of expungement, and making sure that people have the opportunities that arise from gaining expungement. Some of the thoughts are, and we the labels here, we talk about expungement, we talk about sealing. They are what we decide that they are. Right now, of course, expungent is a very broad, expansive action. Sealing is also, as Judge Zone pointed out, the effect is similar, but with an important caveat, which is that it can be used for any law enforcement purpose. And potentially, one of the ways that we can come to agreement, instead of having a two-track process, which was our way of forging compromise last time, it may be that we can forge compromise by redefining what sealing means and who has access. And we would still have to do the thinking on which offenses will fall into the sealing category. We'll have to do thinking. Maybe it will be the case that, and I'm throwing out possibilities here, which we are happy to discuss, but maybe it's the case that the offenses that are currently eligible for expungement remain eligible for expungement, but we don't institute a two-track process anywhere along the line. Perhaps further offenses are sealed, but we address the definition of sealing such that we can forge a compromise where it's the information sufficiently protected to satisfy strong expungement proponents, but can still satisfy some of the law enforcement or prosecutorial concerns that others bring to the table. I do think that is possible. And we can certainly dive into more detail. I'm looking at my watch because I realize there's others who need to testify and I want to give them a chance without running through too much of the time here, but throwing out some of the options that I think are available. I do think there are other ways to reach compromise that do make this system simpler. And one other point I would make, on subdivision 4 of section 5, talking about an automated process. And I would note, as Judge Zone pointed out, that an opportunity to object can be important, and that is contemplated by subsection 4. Connecticut just at the beginning of June passed a law that does actually provide for automatic expungement for a fairly large category of offenses. I was reviewing the statute recently. It's most misdemeanors with a few exceptions, and actually a couple categories of felonies. They do a classification system, which we do not do, but they're sort of lower class of felonies. Less serious felonies are included in that bill. So that is an option that's available, and that would also simplify things, because that would mean that you would not have a petition that would have to go through, although there could still be a hearing if there were an objection. One other issue I did want to address, section 5, I was reminded, does talk about the specific issue of domestic and sexual violence. That is an incredibly important issue. I do a couple things. One, to remind the committee, S7, even in its most expansive form as it passed the Senate, did not include the offenses that we traditionally associate with domestic and sexual violence, specifically, of course, domestic violence offenses, but also things like stalking, harassment, violations of abuse prevention orders. I understand, however, that part of the concern is offenses that are pled down to other offenses and how you deal with that. Offenses that may have really started as DV incidents that then get pled down, as often happens in the court process. 99% of cases in Vermont do ultimately result in plea agreements. And I think that that is something that we are happy to work with the subject matter experts on. I know that Sarah Robinson from the Network for Domestic and Sexual Violence is here to testify, and we are happy to work with them to figure out how to address that and how to balance that. One thing I do want to note is that the process for one thing that hasn't been talked about enough, I think, when we debate some of these issues, is that the prosecutorial objection process is a real safeguard. It's not an illusory one. And by way of example, our office, historically and presently, has frequently prosecuted cases where there's been wrongdoing by police officers in the line of duty. We have gotten expungement requests for some of those cases, and it is the policy of the Attorney General to object to those, because he believes that it is inappropriate for executive branch officials to agree to put a veil over the wrongdoing of other executive branch officials, even though it happened in the past. So we have a case there where an offense, for example, a simple assault, may be generally eligible for expungement, but there is a special category of offenses within that that we believe is inappropriate for us to stipulate to, and so we do object for the reasons I talked about. We can get more into that more if you want at some later date. But I bring that up just to point out that's not a problem with the system that we have to object. That is the system working as it ought to work. And I think that some of the answers here are going to, we cannot avoid having some of these addressed on a case-by-case basis and ensuring that prosecutors are educated and aware of some of the issues that arise with specific cases and the need to pay attention to those issues on specific cases. That being said, again, we do support a broad expungement along the lines of what was passed by S7, although again, as passed the Senate, although again, we are happy to think further about how to simplify the process, about how that happens, how to reduce petitions, reduce burden on petitioners, courts, prosecutors, and so forth. And I think, I really do believe that a different type of compromise, a simpler form of compromise than what was embodied by S7 is available and possible. And we look forward to working with stakeholders to get there.
Questions? Now it's getting your noon time. Our levels are kind of decreasing. Thank you, David.
Thank you.
Okay. Let's go to Marshall Paul with the Defender General's Office.
Thank you. Marshall Paul from the Office of the Defender General. I'd like to thank the committee. It's really good. As everyone has said, it's really good to be here in person. So I wanted to start by just addressing some of the things that I want to start by really expanding on a little bit of what David said about some of the policy reasons behind expungement. And I wanted to get into those because they, David sort of drew a distinction between the policies supporting expungement and then the answers to the procedural questions that were specifically asked of this committee in S7. And I think they're actually really closely connected. I think the answers to a lot of those procedural questions are really given to us by the policy research that's been done. Recently there was, I think it was in 2018, there was a University of Michigan study where they did what was really the first, as far as I'm aware, longitudinal study of people who had benefited from an expungement, able to look at what they, because most of the time the nature of an expungement is once it happens, you've disconnected that person from that prior record, and it makes it hard to research and study to see how successful that expungement process was. In Michigan, the University of Michigan came up with a model that allowed them to do that ethically and allowed them to get their study approved, and that they did this longitudinal study and showed some amazing results. So first of all, in Michigan, just to understand their expungement scheme, you can get almost any offense expunged. The only offenses that are ineligible are offenses with life sentences attached to them, or child sex offenses, or domestic violence. Those are the three categories. And expungement is available after only 5 years in Michigan for all offenses. There are no, they don't differentiate felonies versus misdemeanors in terms of the length of time. So they found that the people who got expungements in Michigan were within 1 year of getting the expungement, saw their wages, salaries increase on average 20% within the first year after their expungement, which is, frankly, incredible. That's a really tremendous result. They also found when it comes to, the big question in expungement is always public safety. And they found that even though Michigan has a very expansive process and a very small, comparatively a short waiting period before you're eligible for expungement, that people who received expungements were actually less likely to offend than the general public after that 5 years. Now, breaking down categories, there was some categories of offenders who might have been more likely and some that were less, but averaging the entire group, they were less likely to offend than the general public. Interestingly, though, and this was one of the big things that came out of the Michigan study, only 6.5%, despite these really tremendous benefits of expungement, 20% increase in wages, only 6.5% of people who were eligible for expungement ever asked for an expungement, which really speaks to this procedural question of, is there a need for automatic expungement? And there absolutely is, because frankly, this is not a benefit that people are going to avail themselves of voluntarily. And yet the benefits will still be available to everybody. An automatic expungement is still going to benefit people. You know, the idea that criminal records are not, really don't have an impact on people anymore is just false. 9 out of 10 employers nationwide, this was a nationwide survey, say they do criminal background checks before hiring. 4 out of 5 landlords nationwide do criminal background checks before hiring. I was just actually on the phone with a former client of mine who has an offense that is not expunged. And I was talking to her about other stuff, but she was talking about her trouble looking for work right now. And if, as everybody knows, if there was ever a time for somebody who has a hard time finding work to find work, it's now. And this woman's looking in all the right places. She's looking at restaurants. She's looking at retail. I mean, those are the places within walking distance of her. So that's really it, is restaurants and retail. She's applied at the 4 or 5 places in walking distance of her. She's been honest and disclosed her conviction, which is not for anything. It's a, you know, it was a interpersonal violence situation in the home, not anything that, you know, it wasn't stealing from your employer or anything like that. And she still cannot get a job, even in today's, you know, very employee-friendly, job seeker-friendly job market. So this stuff really does have serious impacts. This stuff really is, you know, it's not just a benefit to those individual people, it's a benefit to our economy. And frankly, as a public safety benefit, I mean, we know what causes people to offend. We know that it's caused by, you know, the primary drivers, housing instability and economic instability. If you can get people stable housing and stable incomes, they are far less likely to commit offenses. And what is one of the major barriers to getting stable housing and a stable income? It's having that criminal record hanging around your head. So, you know, I wanted to address that. I also want to briefly, and you know, I won't try to touch on everything because I know we're pressed for time, but I wanted to sort of briefly touch, oh, and I also wanted to mention, just because it was interesting, was that Michigan law, University of Michigan study prompted the Michigan legislature also to adopt an automatic expungement scheme. Theirs doesn't take effect until 2023 because they had a lot of, they actually have to essentially implement a case management system in order to implement their automatic expungement scheme. But you know, that drove them to do exactly that, to create that automatic expungement scheme. There's been a little discussion about the difference between expungement and sealing. And I want to say that, well, you know, I think our office is tentatively, you know, interested in the idea of moving to a one-track system. We're certainly leery of sealing rather than expungement for a few reasons. One is, it always does come down to this question of who has access. And one of the fears is giving access to people in a way that that access actually undercuts the purposes of the sealing or expungement or whatever you want to call it system. You know, I think one of the primary areas where that comes up is law enforcement needs. There's always this idea that law enforcement should have access to sealed or expunged records. And that's actually one of the places where we see the most need for there to be separation. And because you know, we see this when we watch, you know, body cam videos of our clients being pulled over. You know, officers ask people questions about old convictions. And, you know, so somebody will walk up to a car and it changes the entire nature of the interaction. When a cop stops somebody with a broken taillight, you know, are they approaching the car prepared to write a warning and be on their way? Or are they approaching the car prepared with their hand on their gun, asking questions about, is there anything in the car I need to know about? And sometimes directly asking questions like, I see you have a conviction from, you know, for possession of drugs. Is that still an issue for you? That's the one that I've seen them ask a couple times. Is that still an issue for you? So the way we see it, there really is a need to keep, you know, whether we call it sealing or expungement, and whether these records continue to exist or don't exist, to us, the idea that when, you know, at some point, these records become unavailable and they're not used by law enforcement and they are not used to make decisions about how you're going to be charged, how you're going to be approached by law enforcement, how you're going to be, how decisions about your access to diversion or to, any of these programs, that your record at some point needs to not factor into any of those matters. That's what we support. And that could be called sealing, that could be called expungement. Other states have all different names for it. I've seen expunction, annulment, all kinds of stuff. As long as what we're talking about is the idea that at some point it goes away, then we're supportive of it. There's been a couple mentions of the idea that defendants, that people who have been convicted may need access to their records. That's true, and we have actually already addressed that. Our office did a sort of deep dive into the various places where people who have been convicted may need access to their records. And the place where we found that it was where the need was the greatest and where the level of detail that somebody would need into access to their old records was the greatest was for immigration matters, for adjusting your immigration status in particular, or renewing a green card, which really is the same process in a lot of ways. And there we reached out to some immigration experts, and they gave us a list of what exactly information you would need to provide, so that, because the way it comes up is during the immigration interview, immigrants are often asked, have you been arrested? And if they answer yes, they got to be able to show what happened with that case. They just have to be able to show. It doesn't necessarily mean that they'll be denied whatever status adjustment they're after, but they got to be able to show it on paper. And when we looked into that, the answer was pretty clear. They need to know, there needs to be some official documentation that's got the name, the date, the docket number, and the result. And that's all. And that's why I think it's 7606, which is, if I'm right, the effect of expungements section, there's a provision at the end of it to keep a special index, including all of that information, and for that information to be available to the individual who wants to use it for whatever purposes they're using it for. So we've been comfortable with that. And we haven't seen problems going forward with that. We've seen people who have needed that information for immigration purposes. And also, I think we pulled it out once for someone who needed it for purposes of trying to get a promotion within the Army, and needed it there, and they were able to access it.
Didn't we provide an exemption in the statute so that someone can honestly, legally answer that they committed no crime?
I believe that's correct, but I mean, what I'll tell you is what I tell my clients. So when I talk to clients who have had an expungement, I say that's what it says in statute. And that's true if you're talking to a potential employer, that's true. If you're talking to an immigration official, if you are putting it down on your, the applications for military service still include questions about offenses. They even include one that says, has anyone told you that you could answer no to the above question because your offense was expunged, sealed, or was a juvenile offense, or all of these things.
Yeah.
It is devious, but so there's, and then also the other one that comes up is federal security clearance. That one I've also told clients, you probably shouldn't, I know what it says in statute, but I don't, there's no law that addresses, if a state statute says you're allowed to say this, and if a federal prosecutor believes that it's that you lied under oath, where is that line drawn? And so for people who are seeking federal security clearances, I've also said, just tell them the answer. Like, honestly, for all the people that I've been advising on that, they were all going to get their clearance anyway. Their offense wasn't one that was going to deny them a clearance, but the potential that they could be accused of lying about it could deny them the clearance. So with that, I'll answer any questions. And other than that, pass it on to whoever's next.
That's good. Thank you.
Thank you.
We are winding down. I feel it. Numbers.
I'm just gonna send you a note. Do you like us back?
Do we want to do that? Folks, do we want to do that? I'm open to suggestions.
What are the alternatives?
We keep working and finish with these folks. We've got 1, 2, 3, 4. We've got about 5 more folks, I believe, to testify.
I would vote to come back at 1.
And then that would push back our raising the age to at least 1:30, 1:45, and then it would push back the DOC facility to at least 2:00, which is fine. We can go,
Because these are all Zoom.
Spend some more time cutting our.
are people okay going beyond 2:00?
How long beyond 2:00?
I have another commitment at 2, but it's on Zoom and I can come down.
I have to be back.
I'd like to finish by 2:33 is what I'm thinking,
I just have to be back. It's opens by 4:30 for daycare.
and that's how long
That's an
ago?
hour. So as long as I'm
Okay,
out by
as long as we're
3:30,
done by 3.
3.
I'm good.
So why don't we
I
take a
prob-
break for
I
lunch?
probably will have to leave at 2:30, but.
Okay.
um,
We'll do our best. And,
Okay.
and Butch just mentioned maybe we could do the raise the age. They're all by Zoom. Maybe reschedule them to next meeting.
Sure.
If folks want to do that. That's an issue with you folks, again, Senator Sears and Representative Grad.
That's fine with me to schedule that for the next meeting.
So why don't we do that? Why don't we reschedule, raise the age for that to our next meeting? I do want to spend some time with the committee to, did we do an August meeting? I don't think we did we? We're gonna do a doodle.
We do.
We do that?
What?
I don't know, I have to ask Peggy.
I know, I don't remember. I've got
We,
so much.
we don't have any other meetings scheduled.
Okay, so we've got to spend some time doing something for that.
Yeah.
I know Thursday is an issue for some folks because there's LCAR that meets. We've got two
Yeah.
members who are on LCAR that also meet on Thursday. Do you meet every Thursday? Every other week, so we could do
And
it
I'm on the pension.
Every other Thursday.
The
Thursdays.
waiting committee.
every week.
Mhm.
Okay, so we may have to do another day. So I want to
Actually, in
spend.
August, it's Wednesdays.
So I want to spend a little bit of time on that and a little bit of time discussing what other agenda items for our next. So let's come back here at